I'm going to talk a little bit about the E. Jean Carroll civil lawsuits that she has filed against Donald because they raise several interesting legal issues for me. The second E. Jean Carroll defamation case goes to trial solely on the issue of damages, and it's going to start on Tuesday after the Martin Luther King holiday. This suit was initially brought in November 2019 and has been delayed due to issues involving presidential immunity, which has been kicking around the federal court system for about 2 years now. Carroll had published an excerpt of her book in the New York Times Magazine in early 2019, where she claimed that Trump had raped her in the mid-1990s in a department store dressing room. The date was never specific as to the day or the month or even the year, but Carroll and other witnesses that she told about the event believed that it occurred sometime in the 1964 to 1996 timeframe. While President, Trump denied the allegations, as he has a right to do, of course. He implied that she had a political agenda, which is fine. He has a right to say that. But then he claimed that Carroll was, quote, totally lying, end quote, and that she is not Trump's type. It is the lying comment that primarily formed the basis for Carroll's defamation suit that she filed later in 2019. The courts will give a president immunity from a civil action for any statement made while president when he was speaking in his official capacity. One issue there is not whether Trump was president. He was clearly still president, but whether the statement he made about Carroll was within his official capacity or his personal capacity. Inexplicably, Trump's lawyer did not raise presidential immunity as an affirmative defense in response to Carroll's complaint. A first-year law student knows that affirmative defenses have to be asserted in an answer to the complaint, or they will be forfeited and waived. The only exception is subject matter jurisdiction, whether the court even has the power to make any decision on the subject matter of the case. The Second Circuit, U.S. Court of Appeals for the Second Circuit, decided last month that Trump had indeed waived any immunity defense that he had by failing to include it in his answer to the Carroll 1 defamation suit. So that has set the stage now for the trial on the Carroll 1 case, and the issue will only be damages for the reasons I'm about to explain. While the Carroll 1 defamation case was bungee jumping back and forth throughout the federal court system, Trump had at least a plausible argument that the statements made while he was president were covered by the court-created presidential immunity doctrine, provided, of course, he had raised it, which he had not, in his answer to the complaint. But then Trump, because he's Trump, decided that he would make the same kind of statements when he was a private citizen and could no longer claim any immunity, of course. So in October 2022, he called Carroll a liar again, and that everything she was saying was a made-up hoax and she was not telling the truth. Actually going a little further than he did in response to her claims made in 2019. Except now he's a private citizen and not the president. This case is now known as Carroll 2. It involves that defamatory statement made in October 22 and Carroll's claim for sexual battery that she was able to make under the Adult Survivors Act, which waived the statute of limitation for those kind of claims, provided the suit was filed within a year, I think, of the Act's passage. The jury returned a verdict for defamation and sexual assault, and awarding her $5 million in damages, taking less than 3 hours to reach a verdict, which indicates to me that the jury was already convinced of Trump's liability based on the evidence they heard, and that most of the discussion probably just dealt with the amount of damages. Trump is appealing that verdict, and he may claim that the Adult Survivors Act is unconstitutional, which has been an argument that's been rejected so far, and will probably claim that the admitting or excluding certain evidence support a reversal in his opinion or his lawyer's opinion, which is generally something most of the time does not work on appeal. Occasionally it can if the evidence is very prejudicial to the losing party, and the trial court clearly made an error under the legal principles in admitting the evidence. The primary evidence that Trump will probably be complaining about was the Access Hollywood tape, which the jury was allowed to view, and you can understand why he would want them to view that. I would just say that everyone on that juror probably already knew about it, so it could not be prejudicial in a legal sense. And 2 women who testified that Trump had sexually assaulted them to show that he had engaged in a pattern of sexual assaults throughout his adult life. Since a jury in the Carroll 2 case had found that Trump had defamed her by calling her a liar, the judge correctly found that in the first case for defamation that she brought back in 2019, that Trump was precluded from relitigating his liability. The jury had already found in Carroll 2 that he had defamed her. And under the doctrine of collateral estoppel that lawyers learn in the first year of law school, parties cannot continually relitigate the same issue over and over again. After it is decided in one party's favor, that is it. That's all she wrote. So the second trial is just going to be on the issue of damages. And Carroll may be considering filing a third defamation suit because private citizen Trump cannot keep his mouth shut about her. And he has called her various things that have not yet been included in a defamation suit filed by Carroll, including calling her a whack job. So that pretty much summarizes the issues in that case, I think.